This is English shorthand dictation number 368 and the dictation speed is 120 words per minute. Ready? Start. We have heard the learned counsel for the parties and perused the material on record. The main argument advanced on behalf of the appellant is that the High Court, in the first round in its judgment dated 30/03/1990, had specifically recorded that the dispute was with respect to 8 cents of land and the construction standing thereon. The trial court or the high court, therefore, in the present round of litigation, could not have confined it only to the construction and not the entire portion of land measuring 8 cents. It is further submitted that under the law of merger, the judgment of the trial court and the first appeal court in the first round of litigation merged with the judgment of the High Court dated 30/03/1990, and it is that judgment alone which has to be read as final and binding between the parties. It is also submitted that the First Appeal Court, in its judgment dated 13/10/2003, in the present round, had specifically recorded that the trial court had no jurisdiction to go against the judgment of the High Court. The High Court, in its impugned judgment, has in fact breached the judicial discipline by taking a view contrary to the earlier judgment. On the other hand, learned counsel for the respondents submitted that the judgments of the trial court and the high court in the present round is correct in law and facts. The earlier round of litigation initiated by the respondents was only with respect to the constructions raised by the appellant, which of course they had lost. The respondents had throughout been in possession of the 8 cents of land. The appellants were never in possession thereof. The judgment of the trial court and that of the High Court deserves to be maintained. In the judgment of the High Court in the first round dated 30/03/1990, it is not at one place but at number of places that the High Court has recorded that the suit property comprised of 8 cents of land, which was the land purchased by the respondents in 1974. It would be relevant to refer to such facts noted in the said judgment. In the light of the above facts, arguments, and findings recorded by the High Court in its judgment dated 30/03/1990, apparently no defense was left for the respondents to take, as it was already held that the appellant had perfected her rights by adverse possession over the suit property, which was 8 cents of land. The construction of the appellant was standing over the 8 cents of land, maybe on part of it, but she was found in possession of the entire 8 cents. The respondents never sought any clarification of the findings of the High Court or the observations made therein, nor did they assail the same before any higher forum. The judgment dated 30/03/1990 attained finality. Interpreting the said judgment, which was clear in itself, any differently would clearly amount to judicial indiscipline. The subordinate judge, in its judgment dated 13/10/2003, had rightly observed that the trial court had no business to interpret the judgment of the High Court dated 30/03/1990 in any other way than what was recorded therein. The doctrine of merger is a common law doctrine that is rooted in the idea of maintenance of the decorum of hierarchy of courts and tribunals. The doctrine is based on the simple reasoning that there cannot be at the same time more than one operative order governing the same subject matter. In the current case, as previously mentioned, the High Court's judgment from the initial round dated 30/03/1990 noted that the disputed property included 8 cents of land, not just the building structure on it. As per the doctrine of merger, the judgments of the trial court and the first appellate court from the first round of litigation are absorbed into the High Court's judgment dated 30/03/1990. This 1990 judgment should be regarded as the conclusive and binding order from the initial litigation. Following the principles of judicial discipline, lower or subordinate courts do not have the authority to contradict the decisions of higher courts. In the current case, the trial court and the high court in the second round of litigation violated this judicial discipline by adopting a position contrary to the high court's final judgment dated 30/03/1990 from the first round of litigation. The argument of the counsel for respondents is mainly that the judgment of the trial court and first appellate court in the first round of litigation clearly stated in the case of the plaintiff that it was with respect to the constructed portion only in which the mother of the appellant was residing and not the whole area of 8 cents purchased by them. The High Court committed a bona fide error in recording that the sued property was 8 cents along with constructions standing over it. As such, the trial court and the High Court in the present round were correct in limiting the decree only to the constructions and not the entire area of 8 cents. In order to test the above agreement, we carefully examined the judgment of the trial court as also the first appellate court. What is discernible is that nowhere is recorded the actual boundary or the measurements of the property in possession of the mother of the appellant. The respondents therein had based their case on the ground that they had purchased 8 cents of open piece of land and the defendant therein had raised construction over some adjoining land and had trespassed over part of her purchased land. We are unable to appreciate the said argument of the respondents. Suit for possession has to describe the property in question with accuracy and all details of measurement and boundaries. This was completely lacking. A suit for possession with respect to such a property would be liable to be dismissed on the ground of its identifiability. Further, it may be noted that if the construction by the defendant were not made over 8 cents of purchased land, then the plaintiff therein would not have a claim to possession of the same. The argument thus has to be rejected not only on facts but also on legal grounds as discussed above. The appeal is accordingly allowed. The impugned judgment and order of the High Court is set aside, and that of the first appellate court, dated 13/10/2003, passed by the subordinate judge, is restored and maintained.